any other court's opposed motions, the trial court, where people are supposed to come to exercise their Section 34 constitutional rights of access to justice and access to courts to have a dispute resolved. That role features, on average, then it did 50 matters per day. On a Monday, usually some of them 4, 6, 8, maybe even 10 if you include the divorces, might be other matters. So let's, for the sake of argument, reduce the figure to 40 matters a day. Those 40 matters that I'm talking about are claims against the Road Accident Fund. So 40 matters a day translate to 200 trials per week. On an average term, some of it longer, but let's take the least then, the shortest term of 10 weeks. So now we're on 2,000 RAF trials per term. Of that 2,000 RAF trials, there might be representation on behalf of the RAF of, say, 10% by the state attorney. 10 to 20% of those matters might settle. Let's take it again at the maximum. Let's take to 10% and then take to 20%. That means that 70% of that 2,000 per term either goes by way of a later settlement or default judgment. This clogged our roll so far that we could not accommodate other trials. We could not accommodate those who want to exercise their constitutional rights until, at one stage, the prospect was until 2031. Now, of course, that can't be constitutionally justified. Of course, as a judiciary, we can't say that we're giving a service to the litigating public of being heard. And that was the principal case management genesis of mediation. Because if those matters are interrogated and there are no real triable issues, no real triable disputes which require adjudication by a judge, then one is just going through the motions of putting evidence together and the parties can either argue on it or agree. And all your mediators will, of course, then immediately agree, but surely this calls out for mediation. It can be a better solution for everyone. So a lot of what I might say might be RAF litigation related. And for the third and fourth term of this year, non-RAF matters don't lose their trial dates. If I say lose the trial dates, the more stick than carrot to force parties into mediation is to say, but you don't get a trial date unless you haven't at least attempted mediation. So that's what the directive says. The directive says you must at least attempt mediation, and how do you do so? Well, with the help of a number of mediators and through a number of meetings with stakeholders, which included the bar, the sidebar, various formations of the bar, the recognized GCB recognized bars, the other bars outside the GCB, Babasa, some of the smaller bars, various attorneys, local associations, the LSSA, etc. We got to the formulation of the protocol, which is part of the directive. Now, one of the questions I was sent beforehand is, and it's also part of the attack which we as judiciary face in litigation on the constitutionality of the directive, is how can we have mandatory mediation? How can we force this, enforce this, force this on litigants? I need not tell you about the international practice. I can do two things: refer you to the other jurisdictions in Africa where there are mandatory mediation. I can refer you to Namibia, in which mediation works is mandatory. And just a short digression on where I wanted to go with the protocol. Namibia last year, well, they published their reports every year of their courts. And their High Court report of last year, the summary thereof was, well, we have 6,840 matters on their roll. I know that's in South Africa a very small division. Well, these matters were all subject to mediation. to their mandatory mediation regime. Unfortunately, they have a very low rate. Do I get the microphone because people can't hear me?
Well, I'll continue. Oh, it's very bad. So the Namibian report said, of that 6,840, they had a very low success rate, much lower than the pilot projects in South Africa, of the RAF and the MEC for Health, and I think it was not even 60%. But despite that, and I'm going to quote their figures, while at the same time saying I don't know how they got to that figures, I don't know how they compiled their statistics and their amounts, but even if there are flaws in their calculations, they indicate one thing, and it's the same thing that mediation reduces the number of matters on the roll and save costs. So all the matters on the roll, they said that they saved on their report 94 million Namibian dollars of those 6,800 matters in litigation costs. Now, if you were to translate the 6,000 to South African ones, and you take the example which I had earlier of just one division, 2,000 per term, then we're beyond that. If you translate that 94 million to rand then and the equivalent, then you can see where we're going with this argument. But then there's another thing which is of very importance to the judiciary. As the last column in their report, they had a column, and again, I don't know how they calculated it, so let's accept it for argument's sake at face value. They said they saved 931 court days. Now, of course, every court day also costs money, but the court days is what interests the judiciary. And one of the questions, getting back to the questions I asked, where I started to say, how can you enforce mediation? How can you force parties to mediate? We distinguish between the mandatory nature in the following sense. We mandatorily require parties to attempt to mediate. Of course, we cannot force parties to come to an agreement. And that's what the protocol also envisages. If the parties have seriously and in good faith mediated a matter, not negotiated, I don't want to use that because practitioners still get confused between negotiation and mediation. If they seriously attempted mediation and they can't resolve the issue, or if there is an issue which they say it needs a judicial decision, it's precedent setting, it is an interpretation of an act or whatever, then they come back to court. That's the mediation report that they have to say, we'll attempt it, done in good faith, and there's no resolution. Then of course the doors of the court are open and will remain open. Now, a number of you are also practitioners in the road accident field, and I'm going to address this briefly before we talk carrying on with mediation in general. And because of the volumes I now mentioned, there are a lot of questions we got in the past month or two since the initial directive and the slightly amended directive. And they were mostly from plaintiff practitioners. And I must say they weren't questions. Largely, they were more complaints. Plaintiff practitioners had gotten into the habit of, I have a number of hoops to jump through. The RF is not going to do anything. As soon as I cross the last hurdle or jump through the last hoop, then I'll get my default judgment. And now, here comes the judiciary who will put another hurdle in the way. And now this is going to be all sorts of problems and so on. That's the negative perception. And it might have been a largely justifiable perception from experience in the past couple of years. It has been difficult to get all role players, and in this instance the RAF, to act to dispel that. It is a large corporate entity that moves as slow as a government department, sometimes slower, which, as I said to someone earlier today, is like honey or maple syrup on a cold morning. It doesn't move. It doesn't come out anyway. And initially, when we tried to ignite the litigation and the mandatoriness of in existing or trial allocated or set down matters, we envisaged then that parties have previously as they were obliged to do in terms of Rule 41A, delivered a notice, yes, I want to mediate, no, I don't want to mediate. Defendant says, well, I couldn't care, I don't want to mediate in any event. And they were done perfunctorily. It was just a tick box, just a piece of paper that went somewhere. Until someone, and these are really the exceptions, wanted to enforce that by way of Rule 38. Well, to circumvent that, we said, no. File a new Rule 41A. File an expanded one. Do what you initially should have done to say, I want to mediate because of the following. These are the disputes. We've already done the merits. It's only the quantum. We think we can reach each other by way of mediation, A, B, or C. And we expect the defendant to do the same. Now, following on my previous topic of the negative issues, it is so that initially the RAF simply delivered notices which said nothing, or delivered non-compliant notices. And I'm not talking because behind the RAF's back, because we debated this with them and also at their request, and I'll get to them as well. And some of the notices just said, I don't want to mediate because your reports are stale. Now that's a non-compliant notice. Of course you can get together and then debate how you're going to solve that or deal with the issue. Or I'm not going to mediate because, what was the other one? I can't even recall the other one. The position of the RAF has changed. We have not been favoured with their standard operating procedures, but I can tell you that they have increased staff, they have a mediation committee, they still consider whether they want to mediate or not in what I think is, this is a personal thing, the thought of mine, is an over-cumbersome way, but that's how the corporate entity works. But the responsive notices have started coming in. There are anecdotal reports of successfully mediated matters, even in the RAF field. There are increasing consents and agreements to mediators. If there's not, well, of course, the protocol says you come to the mediation umpires, which are the JP, the two DJPs, myself, and the acting DJP in Johannesburg. So there are 3 in each division, and we decide and allocate and nominate a mediator. And I've done so in the past week a couple of times. So those are the positives, and the positives will increase. The positives, of course, have a number of additional benefits which go beyond the directive. The directive was aimed at case managing our congested roles and clearing it for really meritorious matters. The added benefits, the spin-offs are, well, at least you get the RAF who has to give attention to a matter which previously it didn't. And there are increasing more merits offers being made. There are increasingly more other offers being made. They are being made quicker and faster than before. And I mention this to you because you will understand that as I stand here today, it's the second day of the 3rd term, meaning it's the second day in which this directive featured at roll call for the past 2 days. So I've heard a number of arguments and responses and also then reports. So that's the one spin, that there's a quicker response. There's at least attention to a matter. Ms. LaRue there told me this afternoon that she's been nominated as a mediator, and then her heart fell when she phoned the RAF and was told that the link number of the claim is a Cape Town matter. As her heart fell, within 2 hours her spirits rose, because within 2 hours there was a response to say, we've found the matter in Cape Town, we've found the claims handler in Cape Town, the person you need to talk to is this, that, and the following, and the matter then progressed towards mediation. If there is a difficulty, it's a mandate, it might be a mandate one which you often encounter, even that can be managed. Those of you who mediated matters before the MEC knows the mandate issues of the province, and that can easily be overcome. So the spin-off is then quicker settlements, quicker offers, and definite attention to matters. There's a further spin-off which I also mooted previously. Often, practitioners find themselves at a lull in their practice, being an attorney's practice, being an advocate's practice. And what to do? Advocates can't tout, attorneys say, well, the work has dried up, I don't know why, how we're going to do it, etc. We have slightly more leeway in advertising, not yet touting, but advertising. And now suddenly this door opens of a potential 2,000 mediations per term. And we know that there are practitioners who are now qualifying themselves as mediators who haven't done so before. And it just opens up a whole new door of transformation of practitioners, of access to a source of income which has not then been there before. There was always in mediation a practitioner's resistance, thinking that they would lose money, etc. But practitioners who didn't have work and so on might now get work. The pie might be spread wider, and that's the transformative consequence of it, which is another beneficial consequence. Luella just now mentioned to me something about, some practitioners, would prefer to litigate and, litigate up to the steps of the court before they consider even settling, and now they're forced to do the opposite and get to mediation earlier. DJP Ledwaba and I were part of a group of 7 judges who did mediation training in Utah a couple of years ago. And one of our mentors and trainers there was a chair of the Utah Bar Association. They don't have a divided bar in America, of course, so the Bar Association, there would have been trial lawyers, which we then call either barristers, depending on where you are in the UK, or then advocates, and attorneys or solicitors. And the firm had 5 partners, and they were a litigation firm. For the past 6 years or 8 years, they're now a mediation firm. Only one of the partners does litigation. All the others mediate. They say they make the same money or more. They make it quicker, because mediation is much quicker than a long drawn out litigation. They make it for them easier, and they have happier clients. So the adversity against litigation should dissipate. That's the other benefit which comes out of it. And then the more the mediation culture takes place, the more attorneys understand that their clients are really their clients. They must look to their interests. They're not just a means to get to a bill taxation at the end of the day. The more mediation will help bring them closer to their clients, but the client has to be there where there is mediation. And even the opponents, whether it's PRASA, whether it's the Minister of Police, whether it's just another litigant in person, whether it's a doctor, a specialist, whether it's an insurance company, or whether it's the RAF, will be brought closer to the person claiming from them than waiting for the adversarial moment in court. And in that sense, the restorative justice, which you all know is part of mediation, will, I believe, take more place. It will make the dealing of claims which should not be in a court more relevant to people, to those who claim. Those are the positives. I was told as well that this is also going to be a question and answer portion. Perhaps I should, for the answer portion, hand over to my DJP Deacon field. But one of the questions I want to deal with and dispel right now is, I got some written questions beforehand, but there was a concern raised, which might be a concern of some of you. The question was this: the protocol makes provision that the mediator must report or can report if mediation is done by one of the parties in bad faith. And the question was, well, wouldn't this now either violate the confidentiality principle, or would this encroach on the role of the mediator, or would this actually make the mediator liable to other litigation, perhaps even have to testify in court, etc. Let me tell you why the bad faith issue is there. It is still a result of that initial negativity. One would often, in RAF matters, and I mentioned the RAF, but it could be anyone else, find in, say, a pretrial conference that someone comes to the I won't say party, because actually the person comes to the pretrial conference but not to the party, because the answer will just be I'll revert, or I deny everything. There's no real progress in the pre-trial conference. And I'm talking to you on the basis that all of you are procedurally adept in these matters. And one wouldn't want that to happen during a mediation, because what's the point then? So there is scope for a bad faith determination by the mediator. And you might say, but now how can the mediator decide bad faith or not? Let me give you a real-time practical example. This morning, matter number, that's which matter it was in the court roll, I can't recall now. Plaintiff stands up and says, we attempted mediation, there's a report by the mediator. And the state attorney gets up and says, yes, I represent the defendant. I concede there is the report. The mediator said this is a written confirmation in accordance with section 2, sub 2, sub 5 of the mediation protocol. You please take note, mediation was requested quite late, so and so, it took place. Then it says, the person sent by the defendant got there and had to concede he had no mandate. Yes, they agreed to the mediation, they agreed to the mediator, and then to send someone, they say, we agreed to all of this is in compliance with the directive, it's fantastic, we will assist you and you can be off the court roll, etc. And so to get there without a mandate is, to my mind, and I put this to the council, is as bad faith. Because if you come to mediate, you're supposed to come to say, let us resolve this. If you come there to say, I cannot resolve, I'm only here to show my face, I'm going to turn around and walk out. Well, that's not mediation. So this is, you get more extreme examples than this, but I think the mediator was correct to say, this is why mediation failed. The mediator didn't go so far as to say it was bad faith, and left it to the court to decide. I allocated the matter to a judge because I found the plaintiff had complied with the directive and is entitled to proceed to trial. Incidentally, just to complete the unfortunate example, I asked them, counsel for the state attorney, so what are we going to do when I allocated you to a judge, and what are you going to tell him about the evidence? He says, I don't know, my lord, I don't have a mandate. But be that as it may. So, to end on a positive, I've seen already in the past 2 days a reduction in the trial roll. If a large number of those matters unfortunately don't get mediated or don't get settled as a second alternative and have to go to the default judgment roll, the default judgment roll might increase, but it might probably be only in the short term until this ball gets rolling and rolling faster and faster. If a previously recalcitrant defendant, and I call the RAF that advisedly because that's what I've called them in the report of judgment. So if a previously recalcitrant defendant, such as the RAF, can start, even though slow as the syrup I mentioned, to get its house in order, then all of those of you who are so passionate about mediation can and should take that ball and run with it. And that's my message as an introduction before I hand over to Llewellyn and if necessary, take questions. But thank you for giving me your attention.
Judge, I think there are questions, and I'll open it up. Just put your hand up if you want to pose a question.
I think I can speak loud enough. The simple question is, the Rule 41A is currently the rule providing for a specific procedure for mediation. How do you get past those in the directives? It says you can't place that 41A before court, until costs, obviously. How do we then place that before court and strike a defense where we're entitled in law to, for whatever reason, refuse mediation? can be fixed up with costs, but the problem lies there in that it's still not mandatory in law. Procedurally, it might be something that you've got to comply with, you might be penalized, but how do you get past, I'm entitled to refuse?
Well, I'll answer with a multi-pronged answer. The first one is, I think that non-disclosure of the Rule 41A in the rule is incorrectly there.
And we've sent letters to the Rules Board to have that removed. But be that as it may, it is there. But Applicant Snyman, if the plaintiff or the defendant now wants to enforce the rule, to say, court, consider in terms of Rule 30A whether my opponent's response is regular or not, then surely the notices come to the attention of the court. It must be, because how will the court decide it otherwise? That's the second thing. The third thing is, the comment you made is the exception, because that rule is only honoured in the breach thereof by each and every party. Having said that, does the directive and the protocol go too far? It goes further than the rule, that is so, and it is justified as it's set out in our directive and in terms of our constitutional prerogative, our constitutional powers of regulating the process in our courts. And I hear what you say, there's a directive on the one hand and the rule on the other hand. But if you want to take the point that to disclose the contents of the Rule 41A notice, contrary to Rule 41A, I think it is 4, 5.
2D.
Oh yes, thank you, 2D. To any court, you're welcome to do so.
The problem lies where you can actually strike a defense for non-compliance, where you can't actually compel a person to, for whatever reason, to actually mediate.
But you've always had the right to compel to strike a defense for non-compliance, which would have been the Rule 30A procedure. The protocol just formulates that for these purposes quicker and easier. You can't compel a person to reach a mediated settlement. What the mandatory directive only does is to compel a person to at least attempt to mediate. John, I'm going to give you the microphone.
I think I can shout loud enough. I think I've got the credibility of being a known opponent of mediation. Okay, I love litigation. I hate anything that's an alternative to litigation. But I think that there's a problem, right? It's a serious problem with these waiting trials for trial. There's no doubt that this is a good faith attempt by the judiciary to address the problem. What's up? We must agree on both. So I think what we have to do is we have to approach this thing enthusiastically and in good faith, try our best to make it work. I think what's needed, because I'm still pessimistic. I remember meetings with the road accident fund people where they said, oh, please come and talk to us and train us, etc. And it just like peters out. And it's not because the road accident fund is a villain, it's because of traditional incompetence. But I do think we must approach it in good faith and enthusiastically. I think all of us need to be enthusiastic to make it work. If you think it won't work, well, the more enthusiastically you try to make it work, the sooner you'll be proved right, if you're right. I do think, though, that communications need to be kept open between the judiciary and us, whoever we are, so that because I'm sure it's a when more than an if. When problems emerge, when we find this isn't working, it's better to do it that way. We don't have, molasses in winter situation. We can immediately talk about it and find a solution to it. Because that's the bottom line. We've got this common problem, we've got to solve it. This is an attempt to solve it, let's do it. Yeah. Because I say, I hate mediation.
Thank you, John. Just in response to that, when you mentioned, your experience with the RAF, our experience with the RAF was initially really very difficult, but we've, and I must break a lance for them, experienced some change. For example, if one of the section heads, not the chief legal officer, because that position is still vacant, but if one of the persons tasked with the administration of mediation say to us, look, there are so many matters on the third and fourth term. Is there a way we can get away and not deal with all the others or the new ones and only these? And we said, no, you've got to capacitate yourself and deal with that. But that's at least a response to say, I have a capacity problem, but I am participating in the directive. For what it's worth, the commitment to the directive has been made in writing more than once by the RAF. And as I say, there are responses. Ask Ms. LaRue. I said to her this afternoon when I heard her story, I said, well, I'll call you as an expert, as a witness then this evening to say how your recent experience was from Pretoria to getting to mediate a participation in mediation from a claim in Cape Town. It might take a day or two longer, but she was surprised that it only took 2 hours to get an initial response. So I agree with John, and I'm appreciative of someone adverse to mediation giving such a positive response. Yes. Well, you did it, Martin.
I don't need the mic, thanks. So Martin Booth, judge, I'm an attorney. I'm going to start by saying I don't need the mic. I like what I hear, but I'm a little bit uncomfortable. I'd like to explain why. First of all, our rules are complicated as they are. And they, in my opinion, make it difficult for many litigants to get proper access to justice. Practice directives on top of that just make compliance as practitioners more burdensome. That's not really my point though, that's an observation, because I think that we need to look at how we practice law and how we practice justice. You use the phrase adversarial on a number of occasions, because that's what our system is. It's very difficult for practitioners to be on the adversarial course and get to a point where they've now got to get on a mediation course. We're not trained that way. And that speaks to my mind that we need to look more holistically at our system, from the rules and the way it's even taught in universities. And I'm going to leave it there, just in expressing my discomfort about let's rush off the mediation and forget about possibly some other things that we need to think about. Thank you, Judge.
Mr. Hood, most of your matters are by way of motions, and I know I've ruled in your favor, but I think I've also once or twice not given you the order exactly that you wanted. The directive is limited to trial matters. That's the first distinction. The second point I want to make is every mediator here who is also a practitioner will say, I thought exactly like Mr. Wood did until I did the mediation course and I understood what mediation then is. I would urge you to consider that.
No, Judge, sorry, if I could just exercise the right to reply. Not against me. If we're going to go to mediation, we need a much more holistic approach to our system, not just in North Gauteng. That's all I'm saying.
Thank you. My answer might have been biased being mediation. There was a question here first, then Dr. Ilan, I'll get back to you.
I'll speak really loudly, thank you. My name's Kayla Dalton and I'm a member of the Pretoria Bar. Judge, my concern is the matters that have now gone through the motions and they, through the directive, are now on the default judgment roll. My concern is because we know as plaintiff practitioners what the defendant is usually used to. And my concern is that what they're going to do on the day of default judgment is pitch up. Now we don't have striking orders. Those we're only allowed to apply for on the date of default judgment. So we're then going to have spent all this time explaining to the plaintiff, sorry, you've lost your trial date, but now we can offer you a default judgment trial date. And on that day, the Road Accident Fund is going to pitch up, and they are going to be obstructive, and then we are going to lose that date. And then we're going to be pushed down the road, even if it's only 18 months, and we're going to be stuck once more. It's an extremely difficult position for plaintiff practitioners to be in. What do we do and what do we anticipate? There is an enormous sense of fear about what is coming. Can you alleviate that?
Well, I think practitioners advocacy training courses of well, one of the things they should have is bravery and not be fearless. That's the first thing. But addressing your concerns, and I also mentioned this to my colleagues often, one cannot allow a previous situation to become a bias. And I have to mention that to colleagues who adjudicate and hear matters of the RAF. If your fear is as a result of past conduct, let's see how it works. You're now anticipating already something which has not happened before. I can only tell you it will have to be dealt with by a judge on a case-by-case basis. If the RAF were to say, for example, I am here, I am late, I know you're asking for default judgment, I'm here because I want to mediate, let it stand down until whenever and so on. That's the one scenario. How can we then say, well, you can't? Well, you know my judgments on 19.5 and when it's an abuse or not. If you're fearful of an abuse, it must be dealt with on a case-by-case basis. But I want to hand over to DJP Ledwaba just to give you the assurance that the default judgments will be attended to. DJP, can I ask you to come in here?
Thank you very much. Good evening, everybody. I'm a member of the Law Reform Commission, and mandatory mediation does the direction that we're taking. Surely most of you are aware of document, whether you call it a green paper or white paper, that has been issued. Mediation is the way to go. From my side, I think if all of us can ensure that we make mediation a credible institution, this will save us. Well, why am I saying it should be a credible institution? Most of the litigants, ordinary litigants, their minds are tuned to that the matter must be before a judge, there should be cross-examination, and so on. However, if the advantages of mediation can be published to them, they understand exactly what is mediation, we can solve a lot of problems. In most of the judicial management meetings that I hold, especially in the presence of the litigants, when I tell them about what about considering mediation, most of them would be hesitant that the matter should go to mediation. But immediately when I tell them, what about appointing a judge to mediate? Almost in all the matters they agreed to that, and those matters were successfully mediated. So what I'm saying is that if people can have credibility to the institution, we are going to see most of the matters being mediated, and this will resolve the problem. Of course, there will be challenges here and there, but I'm hopeful that if you can hold hands together and not make mediation an institution to fill other professions' pockets, but mediation should be there to reduce the number of matters, and as my colleague Judge Davis has said, there are those who tell you that the more matters they mediate, the more they make more money. So from the judiciary, we want to see this happening so that the only matters that deserve the attention of the judges should come to us. But if we all hold hands together and make mediation to be credible, we'll see the benefits thereof in about 6 or even less time. Thank you.
Thanks, DJP. I can also add to that we will capacitate the default judgment role as set out in the amended notice of motion. So if you lose your trial date, but you qualify for default judgment, we will hear those matters where it involves with the registrar. And a second thing I want to add is this is the first such directive and the first time the protocol runs. As the DJP said, there might be legals here and there. We as the judiciary and those who assisted us in formulated the protocol are always open to responses. If, for example, parties have come to say, you know what, if you have a look at section so-and-so in the protocol and section so-and-so in the protocol, there's a difference between a 5-day and a 10-day requirement. They don't speak to each other. We say, thank you for pointing that out. We will correct it. So any other technical amendments, of course the judiciary will listen to any and every suggestion. DJP?
I heard somebody saying that the mediation is something that is only practiced in Guateng. There are 7 judges who are appointed by the Chief Justice to advise him, because Chief Justice Mokoe, and also our new Chief Justice still recognizes us as a committee that would be advising her on mediation. And I've got no doubt that the mediation is going to roll in other divisions, because the JP of the Western Cape Division is a member of our committee. And she has indicated that she's also supporting that there should be mandatory mediation. The JP of the KZN is also a member of the committee. She's also indicated that she is supporting mediation. So in the very near future, you're also going to see other divisions also implementing what we have started in Guateng. And let it be our responsibility as practitioners, as judges in Guateng, that we show the other divisions that this is the way to go. Thank you.
To add to that, just on experience, the JP in KZN last month requested me to mediate the matter in her division, which needed someone from the outside. And after a day, I was happy to give her the one-liner, the matter successfully mediated to an agreed conclusion. Dr. Yedlin.
Thank you, Judge. I'd like to pick up on a very important point that John Mullins made and also that Judge Davis made, and that is good faith. Every mediator gets 2 parties, and the mediator sits there with an open mind in good faith, expecting that both are legitimate, both are going to tell the truth, both have got the same equal rights, and it's not up to the mediator to make any value judgment about one or the other. That aspect of open-minded good faith is inherent in mediation. Now, my suggestion, as John suggested, is that the legal fraternity should exercise the same good faith about mediation. And what I want to say there is there are many people who call themselves mediators who may not really understand mediation. Now, the Gauteng Division of the High Court has gone to great lengths to ensure that mediators who qualify according to the protocol are competent and experienced mediators. And they have made certain requirements, and then the final judgment or evaluation about a qualified mediator is made by recognized mediation organizations. So those are organizations who for years have been training mediations, who've been involved in mediation, who know who understands mediation and who doesn't. And if any mediator is not up to scratch, those RFOs have got a duty to be able to hold disciplinary hearings about incompetent mediation. And I know that from interaction with them, they take this responsibility seriously, and they hold back enthusiastic people who want to start mediating tomorrow, so they feel need some more experience. That's part of why I'm saying good faith. The other aspect is what Judge Davis mentioned, that lawyers who go on a mediation training course and suddenly get it, what it's about, they then become enthusiastic. In the experience I've had with many lawyers, since 2016 when I trained as a mediator, is that everybody who was against mediation has never been in a mediation. I haven't found any, maybe there are, but I haven't interacted with any lawyer who's been in a mediation who's against mediation as a principle. They can all say that mediator was stupid or that party was stupid. There will always be problems. The other thing is that in our Gauteng, the RAF Samba pilot project, we mediated 100 matters. It was part of a research project, and at the end of the mediation, we asked everybody, what did you think of the mediation? And the parties were a plaintiff attorney on the one side and an RAF claims handler on the other side. In almost every case, the RAF claims handler was ill prepared. Not through any shortcutting of them, it's just that they hadn't been taught how to evaluate, how to prepare, and to put a monetary value to things. So all of them came in at a disadvantage. And because they came in at a disadvantage, they felt cynical, they felt defensive, and they felt they're not going to cooperate. But every single one warmed to the atmosphere in the mediation, and they found they were actually being treated with respect. They were being heard, and what they said was actually given back to them, and they I've been understood. And through that process, every single one of them, at the end of the day, said they approve of the process of mediation, and they also approve of the outcome of mediation. So a single mediation was able to convert RAF claims handlers who were opposed to it to supporting it within one mediation. And for that good faith, I think that the legal fraternity should consider that. Thank you.
Thank you. There's a question there at the back, Llewellyn.
I would like to ask more technical, two technical questions involving the implementation of mediation. If the plaintiff has served the Rule 41A notices and we have suggested mediators and the defendant has served and they
Sorry,
opposed.
just excuse me for a moment. Yes, thank you. Yes, sorry, the technical question is?
So the plaintiff serves Rule 41A notices, we suggest mediators. The defendant comes and say we disagree with your options, we suggest these people, and the plaintiff rejects. Now we need an umpire. What is the umpire process and timeline?
You send me or the DJP an email. We'll send you an email back saying we nominate mediator X. We did not prescribe procedures for that. We didn't want to add any other layers to it. It is the same as when a litigant wants a preferential date from the DJP. It's by way of a letter motivating it. A simple email, a simple letter setting it out will suffice both in Pretoria and in Johannesburg.
Am I allowed another question?
Yes.
Thank you. So you can theoretically save your 2025 matters with complying and applying for the prioritized default rule. But what about our matters as set down for 2026, 7, 8, 31? And matters which have not been applied for trial date yet. What's the process there? Will there be a prioritized default rule for all of those matters, or will we go to 2032?
Well, firstly, know that 2032 is where the default role ended up, and as we address the trial role, that of course can't be, and we'll address that issue. That's still a work in progress. As to your dates of 2026, you asked. Well, let's just see what the protocol says. Revision of the status of trial dates for cases allocated other than RAF against the RAF in 25 and 26. In respect of the trial dates in 2025, shall remain intact provisionally, subject to the procedure. All trial dates issued to cases against the RAF from 1 January 2026 are withdrawn. All such cases set down of the date must seek fresh set down, and the request must be accompanied by a mediator's report. So to get a trial date, you must get a report of an attempted mediation, unsuccessful. But while I answer that question, let me also immediately add something which a lot of practitioners forget, and Advocate Steinman, even Rule 41A refers to that. You need not mediate the whole of the matter. Of course, that will be magic. But if you, for example, mediate the merits, or as we see in many cases where merits have been either conceded or agreed, or there's an apportionment, and you have to deal now with the issues of quantum, you can mediate the same as you do your separation in court of heads of damages for past medical expenses, the undertaking, and the loss of earnings and capacity, separated from the general damages. You can do that in mediation as well. We can either mediate this or the other, or both. If what you can't mediate, there's a real tribal issue, well then you go to court and say, here's my mediator's report, we settled all, we mediated all of this, we need a trial date for this, and you'll get a trial date for that. But then the benefit will be, if this works, your trial date won't be in 2029, it'll be next year, because the roles will have been cleared. So that's the additional benefit of it. There's a question from the annex as well. I recognize the annex as well.
Thank you. Good evening. My name is Nicole. Good evening. I must say, what is actually unfolding here in Gauteng, in the manner in which it has unfolded, it's such a very big step. And I must say, it's 5 steps forward. Comparing to, we've been on the court-annexed mediation that was previously done by the former minister, and we've seen how it did not actually serve most of the mediators who are actually there. Mainly because it was just a list that was actually there, and then it did not have a lot of information, the processes how it's done. Besides having a court-annexed mediation being done, what we did in the portal with the regional courts to make sure that mediation is done in court, we grouped ourselves together as mediators and worked with the courts in ensuring that mediation is done with all the stakeholders that were actually there, including the legal practitioners, every stakeholders, to make sure that they have a buy-in in terms of making them to be more aware of what is actually the process is. Throughout the whole process, we've been doing it since the past 5 years, even now, whereby we are actually doing mediations in court. Because in most cases, in most provinces, we've seen that mediation are actually done in private spaces as opposed to are actually done in the court process. Or you find out that the judiciary is the one that is referring a matter to be mediated in court. The process, it actually involves whereby a mediator gets to mediate with either parties or together with the legal practitioners present. What we did, it did not actually end there. It became as an upscaling whereby we got newly trained mediators who've never had the experience of getting to mediate with real people, real emotions, real case, not a mock or a case that was just initiated to say, let's mediate on this. You know at the back of your head that this is not real, but we get to do it with real people, real case, real emotions. And I must say, 80% of the matters that we mediated successfully, they were done. And they were even given preference because we had a meeting with the judiciary to inform them that once the matter is being settled at mediation, it could even get on the roll the following day. So there's a lot of flexibility around mediation. We must also take into consideration of the emotional damage that is actually being done on the parties, as opposed to the legal representatives who are actually there. We must also take into consideration of the economic damage that is actually there, money that is actually involved. But be it as it is, throughout this process, you get to learn, you get to be upskilled, and you don't stop to learn because each case has got its merit. And you must also learn some emotional intelligence in terms of you will know that this kind of matter that involves this kind of people or people are not ready to mediate. You as a mediator should actually know when to stop and not to proceed, because sometimes you will cause more damage over something that you could have just left. But I must say it is possible. With the capacity that I've also saw with how the protocol has actually come together, we are willing, we are ready. The most important thing is to work together and share the experience that is actually there among different people in different fields. And taking into consideration as well that sometimes you are not actually dealing with a dispute, you are dealing with the character of a person. Thank you.
Thank you for that contribution. And that experience that you've now heard evidence about extended to the district court and the regional courts in Limpopo. And you've also now heard that from a mediator with, how many years do you have? 16 years experience. Yes, another question from the annex.
Simon, good evening. I've arrived late, but I have two questions. I heard the judge said that you need to have a case that the matter must be on trial for you to apply for mediation. So my question is that if the matter is not on trial at all, can one jump the gun and apply for mediation? That's the first question. I'm not in RAF matters, but I have heard one of my colleagues, they said that there's this thing where the RAF, especially the claims handlers, they would say, because I want to marry it with mediation. That's what, for instance, the matter goes for mediation, and then the legal practitioner is appointed in mediation in terms of Rule 41A, and then there arrives the claims handler or the senior claims handler, the team lead or the manager. There and there, when the matter is about to be mediated in terms of quantum, then the RAF, they say, no, in terms of the matter of Lebeco, we reject the damages there and there. Then how is the mediator going to maneuver on that one? They say, no, we refer the damages, and then the matter is it's not on trial or it's on trial. But they just said, no, we are not entertaining the quantum. We are just referring the damages, and then we have a case law, the Lebeco matter, the constitutional court. So I just wanted to hear from the panel, from the judges, that how do you go about it? That's the first one. The second one, can one go through the mediation without the trial date, or is it specifically for trial date? And if it's so specifically for trial date, then why can't we just fast track it and say then we can even go straight for mediation, even though we don't have a trial date? Thank you.
The first question is the easiest one to answer. Of course you can go straight, as you say, to mediation. Rule 41A has not been abrogated. The directive and the protocol is additional to Rule 41A. Rule 41A obliges the plaintiff or the applicant to deliver its notice to say, I want to go to mediation, and the defendant do the same when it answers thereto. And that process remains intact. It remains intact for any matter, any application, except Mr. Wood, you're going to have difficulty with the police, with your applications. But, so the first question is, of course you can go to mediation at any time in any matter. The directive is currently limited to Guateng to deal with the volumes, which I think you unfortunately missed when you came in, to deal with our case volumes in trial matters. So the directive is limited to trial matters, and the protocol follows on that. But you can mediate any matter, and if you can mediate any matter, you can of course then mediate it in the manner in which you and the mediator then agrees in the mediation agreement. Or you can decide by agreement then to say we will follow the protocol process, etc. But you can mediate any matter anytime. The case of the Lebeco and the claims handlers, I hope will not arise again. having regard to the RAF's commitment to mediation, but I'm not going to make any other pronouncements on it, and I'll leave it that to, if it does happen, for the mediator to deal with in each individual case. But there's no blanket denial, so we're not going to mediate Guateng. Not at this stage, not from the RAF officially, and not in any of their response notices that I've seen.
Greetings, Judge. Greetings, colleagues. From the Jury of Ledwaba. Judge, I have two concerns. As junior members, we are obviously sent to these trial interlocutory courts on a day-to-day basis. One thing that I've experienced at first was the compliance with the aspect of the general damages, and then you have your order that you are asking for a strikeout. Then some of your colleagues tell us that it's not in the rules, there's nothing that suggests that the defense should be strikeout. Now we have this aspect of compliance on the mediation, and my learned colleague raised the concern of I'm not forced to mediate. What if I come across a judge that says, look, I can't force them to mediate. Yes, you were granted that order, but I can't strike out the defense. What do I do as a junior in this instance? Because most of the times we come across that, and you say, but the practice directive says this, then it says I'm not bound by it.
I hope your question is historically based, because it is very easy currently to turn to the directive, and the protocol 493 of the protocol says if a party is delinquent, that is now a party who refuses to mediate, well, not refuses, who refuses to give you a response, a 41A response, or a non-compliant 41A response, then that party will become a delinquent party. The aggrieved party, then 493, should the delinquent party fail to comply with a compelling order, so the compelling order will be you are compelled to give a proper response to the mediation. And if that response is with valid reasons, no mediation, well, that's the end of that matter. If there's no proper response, then the delinquent party will be compelled to give a proper response regarding mediation. If the delinquent party does not comply with a compelling order, well, then what's the consequence? The aggrieved party shall, upon production of proof of such non-compliance on affidavit, get two things. One, be excused from not having subjected the matter to mediation. So there you're excused from the mandatory issue of it. But then secondly, you don't have a trial now because there's no disputed issue. It's a non-triable issue. Then you can go to the default judgment, you get leave to go to the default judgment court. And there you ask all the relief that you seek. The relief might then be striking out, or it might be, well, I didn't even strike out the defense, but because of the default of appearance, I want now my order on merits, I want my order on quantum, or I even want my further order, as otherwise indicated, on contempt of a previous order. So that's the position. But can I put something else to you? If you say the junior bar goes to the TIC court, of course, if you're a qualified mediator, then you'll be in demand. More so than in the TIC court. So we're at some stage going to cap this.
This is a very political question. It's for all civil trials in the Gauteng division. Does that include or exclude before the Commissioner of Patents?
That's a good question. For 2025, of course, I can say it excludes that. As to whether it includes matters before the Commissioner of Patents, as the directive is now formulated, those will be included. But that can, of course, be easily a matter to say, well, it can't be mediated. We've attempted to limit A, B, or C, depending on whether it's damages or not. And then if it can't be mediated for a valid reason, then of course we'll get your trial date. But, let me repeat again, if this mediation project works in respect of those other matters which shouldn't have been on the trial roll in any event, then your Commissioner of Patents matter will be able to come in, say, second term next year instead of 2029. Thank you.
We're going to take one or two more questions before we take questions from those joining us online.
Good evening, Judge. I just want to find out, I need to explain this concept of mediation to my client. You say to him, well, now you need to pay because we need to pay a mediator. Do we have actual proof from the RAF that they're going to pay the 15,000 rand? Because now I must ask my client, bring me money to be the mediator. Do we have that proof, and can we get that proof, can we circulate it, and I can show to my clients that there's a commitment from the RAF? Because my clients also see the news, the order's been resolved, CEO is a lot of stories, there's no going to that. So is there an actual proof that I can show my client, Delmos or wherever I am, to say there's a proof, there's a commitment from the client?
I can give you the assurance there was that in writing, but it's not, it was qualified depending on how much it might be to a mediator. I would rather do the following, and I would request you to ask your MRO to confirm to you how many of the mediators have successfully mediated an RAF matter, and find out whether there were in those matters, on the agreement then reached, probably be made in order of court, a payment for costs. I can't now give you that letter, but I can give you the assurance there was such a commitment. DJB, should we add to that? Mr. Bauer.
Thank you, Judge. I don't actually have a question, just two comments. The first comment is that I actually just want to add to what my colleague said about a relook at the way we access or practice justice in South Africa. I agree. I believe that not enough focus is placed on alternative dispute resolution in our legal education on the tertiary level. But I actually believe that we need to re-look at how we deal with conflict in South Africa on a broad level, in a multiracial, multilingual, multicultural country. We need to actually learn how to deal with conflict. Nobody teaches, even on a primary and secondary education level, teaches us how to deal with conflict. And I think that's actually where it needs to start. And that could be transformative as far as our society. And to tie in with that, I need to say that I used to be one of those skeptics. I used to be one of those that were very opposed to mediation because of a bad experience I had in a matter in what was termed a mediation, but not conducted by a trained mediator. And it was a tragic matter. In fact, I heard today that one of the parties committed suicide. That's how tragic it was. Until I finally got into a matter with the trained mediator and saw what was supposed to happen and how the parties were actually affected and how that was addressed as far as the dignity violations were concerned, as far as the parties and how they were affected were concerned. Because there's a cost to litigation that doesn't sound money. And as practitioners, we often lose focus of that. And if you have a properly trained mediator, they'll be distinctly aware of that, and they'll be able to address that, and need to address that. Those are not the type of things that our courts were made for. Our courts are there to apply the law. And the Constitution says if it can be resolved by the way of the application of law, then you have the right of access to courts. Most of these matters do not have to be resolved in that matter. They can be suitably dealt with in mediation, and I would encourage the parties to really embrace this.
I've been advised by Llewellyn that the online questions will be dealt with separately and by way perhaps of more formulated questions and formulated answers. The purpose of the rest of the evening is of course to workshop and mingle and then let the enthusiasm to mediated agreements, percolate amongst you. We appreciate from the judiciary side, my the Deputy Judge President and I appreciate those who had expressed concerns and reservations, but equally so, we thank you not only for hosting us, but we thank you for displaying, as Dr. Erlinger says, your bona fides, your real commitment in finding a solution to overwhelming litigation. We thank you for that, and thank you for your time.
Thank you very much, Judge. Thank you very much, DJP Ledwaba and Acting Deputy Judge President Davis. Valuable insights, and thank you for everyone's participation. I think, as Judge Davis has said, everyone feel free to have a bite. There's refreshments in the back. Perhaps Judge may hang around for a little bit, and you could perhaps pose some questions, but we'll be here for a very long time. We'll have to answer everyone's questions. We're going to perhaps compose a frequently asked questions list, ADR Network SA, and perhaps we can ask Judge to assist us. But thank you so much. Please feel free to help yourself.